Atlanta News First Plus starts now.
And thank you for joining us here at the First Alert Desk on Atlanta News First Plus. I am Maria Moreau, joined by our legal expert, criminal defense attorney Joshua Schiffer, as we continue to follow gavel to gavel the trial of Colin Gray, the father accused of being criminally responsible for the shooting in 2024 at Appalachia High School, where his son, Colt Gray, is suspected of carrying out a mass shooting that killed 4 people and injured 9 others. And I want to bring on now Joshua Schiffer here joining me. Josh, we spoke yesterday, day 2 of trial, and kind of what the arguments and the focuses for the prosecution and defense was. Right now, we're still waiting to hear from the defense, but today has already been such an emotionally charged day of testimony, of bringing forward evidence from that tragic day 2 years ago. So I want to focus in on day 3 and some of what we're hearing so far. Let's start by your initial reaction to what today has held.
Well, clearly the state is doing an excellent job presenting additional direct eyewitness testimony of what happened on that fateful day. And they are doing it in an appropriately respectful manner that sets the tone in this courtroom. And this is an extraordinarily serious matter, as much as it's going to be heartily contested by the defense when they get their right opportunities. But it would be very risky and ill-advised for the defense to attack these witnesses in some sort of aggressive fashion. So we're not seeing that. Right now, this trial, being that it's going to last a few weeks, it's still in the warm-up period. We've already heard from both the state and the defense what we expect to hear in their factual presentations. Those were in the opening arguments this past Monday. And since then, the state has presented multiple witnesses in a straightforward, very clinical manner, explaining what they witnessed during and immediately after this horrific set of circumstances. We're not going to see really the flashy parts until there are some witnesses that the defense can really get in the mud with. Getting in the mud, arguing, pushing back on what these otherwise unimpeachable people are going to testify to. What happened? What did they see? What did they experience? What were their feelings? You don't want to go scorched earth on those people at this point. That would be a huge turnoff for a jury who is very much intent on listening, learning, experiencing what happened.
Yeah, certainly. And that's, I want to get into some of the specifics of what we're hearing as we follow this trial. But first, more broadly, we are talking about Colin Gray, who is not accused of carrying out this mass shooting, but is accused of not being responsible and working with his son, getting his son help. However, the prosecution is painting this and foreseeing in the prosecution's eyes that something like this could have happened and that it could have been prevented. So let's talk about some of that testimony and some of the evidence, the blood-stained clothes, some of the more graphic things that are being presented in front of this jury. And focusing on the father, Colin Gray, what is the strategy for the prosecution in bringing up the specifics of what actually took place in that mass shooting, as opposed to the lead-up that more so arguably involves Colin Gray?
Well, by putting forth the results of the actions Colt Gray allegedly committed, that being this assault using a firearm with all of these deaths and victims, establishing that event is key, because Colin Gray is accused of being the only person who could have prevented that, or at least the main person that contributed to it. And that's at the key of the state, or the center of the state's argument. We heard that in the state's opening statement, where from the very outset, the state said this isn't a case about what Colt Gray did. And they want the jury to consider Colt Gray basically already convicted. There's not another suspect in that murder. There's not another person that's been accused of being involved. No, the actual violent acts are indisputably those of Colt Gray. So the state started off their case by saying this case today is against Colin Gray, not Colt Gray. We are here about what Colin Gray did, what he failed to do. It's his actions that the state is asking the jury to focus in on, because the defense clearly has a path of, hey, they're putting my guy on trial for something somebody else did. And you've heard the defense repeatedly emphasize that, and we're going to hear more of that as the trial goes on. Hey, they're charging me for somebody else's crime. It's not me, it was them. They told you it was him. They're just grasping at straws out of anger and frustration and emotion, trying to wrap up the parents of this bad guy, and it's vindictive. It's an expansion of what the state's role is. Those are going to be the arguments that the defense is going to make. They're just hard to present in a direct manner. The state is going to present loads of opportunities for Colin Gray to turn around and just take the ostensibly reasonable action of restricting his son's access to firearms. And that's the key nexus point this court is looking at. What access was available, what warnings were available, and was ignoring the multiple repeated warnings from state and other authorities about Colt Gray's behavior, ignoring the warnings that he was fascinated with school shooters, ignoring his obsession with firearms. When did ignoring that turn criminal? Is it a crime to ignore? And did that ignoring Colt lead to Colt's violence? And the state has that pathway. It exists. It's rare. It's novel. This is the first time it's been tried in Georgia. We've seen it successfully applied in the Crumbly case in Michigan. But this is Georgia's first go at this particular criminal theory. And I believe they have a strong likelihood of obtaining the basic conviction, which then leads us to the real issue. This is an appellate case. This is a new case with a reasonably new theory of how to prosecute. It's the first time in Georgia history we've ever had someone prosecuted what somebody did with a firearm that had been made available by the defendant. And we don't know how a jury's going to respond to that. The state really wants to make this non-polarized. They want to make this short, sweet, and to the point. Colin Gray was the last person and the person that provided and made it possible for Colt Gray to do these violent things. And he'd been previously warned about Colt Gray, and therefore he is guilty on a negligence theory of these crimes. The appeal, and this thing's all going to be about the appeal as far as I'm concerned.
Yeah, certainly. And you mentioned the Crumblies, and I want to draw some comparisons here, because another facet or aspect of this is that we are seeing the prosecution of the father of a child who is accused of carrying out a mass shooting before we even see that accused shooter see his day in court. Colt Gray is not expected to face prosecution until much later in the year. Colin Gray's trial is happening now. And so you have this situation where the child who is accused of committing crimes has not been convicted of that crime, and now we are focusing on the parent and his alleged role in that crime. So explain that part to me.
Yeah, so Georgia courts have extensive discretion on how they schedule things. It's one of the core functions of a court to determine when stuff goes to trial, when stuff is dealt with, and that's placed inside a broad set of rules, things like statute of limitations and very specific rules and laws about when courts have to do things. But really, the vast majority of scheduling is just up to the court. And the court saw that Colt Gray's mental health evaluation, which is a mandatory and necessary part of his overarching case, that was going to take a minute. That's because Georgia really doesn't spend very much money on mental health programming. And there's a huge backlog with people with mental health problems waiting to be evaluated by state doctors. And that process is just a disaster. So the court, back in December, found out that it was going to take a minute for Colt to be ready for further due process and decided to try this case first. Strategically, what does that do? Man, it impacts everyone. The state would love to have come in with the existing conviction of the son, as well as all of the testimony used to convict the son, which I believe the state's going to present a very strong case at that juncture. Being able to use all that testimony in the prosecution of dad. They don't have that opportunity now. But at the same time, it doesn't harm the state's case particularly because, like we were just talking about, it's basically assumed and admitted and convinced that Colt Gray did the shooting. No one's standing up with an alternative. But strategically, on behalf of the dad, what does that do to this trial? Does it allow Colt Gray to appear as a witness? It actually does. Or is the value for the defense of Colt Gray being the empty chair, just pointing at it and saying, hey, state keeps talking about what this empty chair did. This empty chair took a firearm, committed a crime, murdered and shot people. It wasn't my defendant. It was this empty chair. And that could be a very influential point made with a jury. It's a successful defense to point at a more culpable person, especially when we get to this novelty of a prosecution. But I believe the state's going to be able to deal with whatever argument the defense puts up when it comes to Colt Gray not being prosecuted by the time the trial against his dad is going forward. And we'll see how that impacts what's going on.
Yes, we will. And just to clarify, we have not seen Colt Gray called to the stand in his father's Colin Gray's trial as of yet. But I am curious, and you kind of touched upon this, what are the advantages and disadvantages of having Colt Gray in the room as opposed to pointing to that empty chair?
He's an emotional magnet. The moment he is in that room, everybody is going to be staring at him. He's going to be held in some sort of, very specific, strict, and apparent custody. I imagine there would be some motions practice about whether he's allowed to appear in street clothes, but he's not the defendant. He's a witness. I believe that he would be appearing probably in orange, wearing cuffs, but you never know. And the state could choose to lean on his presence in the courtroom and point at him as being basically a co-conspirator, an unwilling co-conspirator, didn't necessarily want to involve his dad, but necessarily did. At the same time, the defense has some good stuff that can come out of Colt Gray. If Colt Gray can establish typical teenager things like, I didn't tell my parents the truth, I hid all this stuff, no, my dad and mom really didn't know what was going on, that's a direct refutation and rebuttal to the state's main theme that Colin Gray knew or should have known that Colt Gray was going to take an ultra-hazardous instrumentality and harm people. So we've got that interesting, but it could also appear very contrived and curated. When an alibi witness appears in the middle of a trial and says, hey, don't convict him, it was me, the juries get a little cynical with that. They're not dumb. They can see when someone is trying to go out there and is obviously using self-serving testimony to protect themselves or other people. Doesn't mean that the testimony doesn't come in, but the weight and impact as interpreted by the jury, that's going to be up to the jurors. And there's some big exposures for Colt Gray as well. If he testifies, that then subjects him to cross-examination. And who knows what that would look like? It would probably not be in his best interest, Colt Gray, to subject himself to cross-examination. But how do you communicate that to a jury? Or can you communicate that to a jury? Oh, jury, you would hear from Colt Gray, but you know you can't. But you know that because you didn't hear from him, Dad's innocent. How do you arrange that argument so that it lands with the jury without being able to just say it bluntly and straightforwardly in closing or something like that?
Yeah, and we're talking with Attorney Josh Schiffer, not connected to this case, but here as our legal expert, really breaking down and contextualizing what we're watching. I want to get into the specifics of what we've seen between yesterday into today with some of that testimony, because a lot of this is about prevention and responsibility and where the burden falls. We heard testimony from a teacher, Suzanne Harris, who said that she'd emailed the assistant principal about concerns over over Colt Gray asking about shooter drills and his suspicious backpack. And we also heard testimony where Assistant Principal Day Martin testified that there was no current photo of Colt Gray in the system when they had tried to alert officers that tragic day. She went on to say there was some kind of mix-up in her testimony. Now, I wanted to ask you this. Could we see liability issues for the school district, and how does it potentially provide the defense with an argument about Colin Gray not knowing or should have known that this was going to happen, but then also the burden of the school to know as well?
So you are getting into the great stuff, because how the civil process regulates schools is not something we haven't thought about before. It's actually a big issue. We've seen it in multiple cases where injuries, deaths, other things have happened at schools. And in Georgia, it's basically impossible to sue a school. Because it's basically impossible to sue a school, there's not really an incentive or disincentive to address school operations and behavior, because all the employees know that they ain't never going to get sued. So there's just no person to go in and be the enforcement. My firm actually set the record for several years of the highest recovery for an injury at a school, but that's because we turned it into a fire case and not a school case, because it is almost impossible to sue schools for torts and other injuries due to the way the system is set up and the constitutional protections. But that obviously manifests when you've got emergencies. Since there's not that impending threat of future litigation forcing the organization to have best practices, the best practices kind of suck. And we saw that with the fact that they didn't have a recent picture of the young person. I bet private companies subject to lawsuits, their HR works better than that. Their interior security works better than that. And that's one of the trade-offs we have as public schools are a government institution. You need to prevent them from being mercilessly abused by the justice system. But at the same time, the opposite end of that is now no one sues schools, so the schools never improve their processes. By not having liability be ever findable against the school or school actors, there's just no reason to fix stuff. And we're seeing some of that here. An email from a teacher about a student specifically in these violent issues, shouldn't that have triggered some more responses? We're hearing continuously that Colt Gray was observed by multiple people in, around, employed by the school, agents of the government, and warnings were made, at which point that person just walks away and never has to worry about it again, and neither does the person who received the warning, because they're never going to face any accountability for missing that warning. Well, now we're going to explore how that works. And whether there are going to be civil suits, I assume there are, that's going to explore some of these damages issues. The families of the victims have, in my opinion, a pathway, a difficult pathway, but a pathway against the school saying, hey, you had all this prior knowledge and warning, and you did not protect my child who had no alternative but to go to class. We're suing for the value of the life of my child. That's going to be fascinating. Civil, different ball of wax entirely, but how that affects the criminal process, oh yeah. The defense is going to be able to make a lot of hay out of the school doesn't do this and doesn't do this and doesn't do this and doesn't do this. Why? There's no incentive or requirement that they do it. Why? Because if the government writes a rule for schools, then you can sue them for breaking that rule. The system is set up so that if there aren't policies, there can't be lawsuits. The moment there's a policy, now we could sue someone for violating a policy. By not having policies, that's the schools protecting themselves, but allowing tragedies like this.
And we know that parents are held to a different standard, of course, as we're seeing play out in court here. But is there any benefit to the defense saying, well, if we can all agree that this was unforeseeable for the school, then why can't we afford Colin Gray that same grace?
Excellent point. You put that beautifully. And you're right. The school and the state likes to eat from both sides of the trough. And we'll see how a jury thinks about that when it comes to prosecuting a debt. So when talking about this with colleagues and friends, and we do role reversals about who we would want on a jury, anybody that's raised kids has a different perspective on the challenges involved than someone who has not raised kids. I think that people are tempered in how they view young people when they've got their own one and have been exposed to how they act, because 14-year-olds, man, they act different depending on the time of the day and their developmental stage. And some of them grow and mature faster and slower than others. And then there are they just make different and unpredictable decisions. Well, they're kids. Their brain isn't done developing. They're not using the full mentality that they will eventually develop. That's traditionally been why we don't keep them, or we don't allow them to be held accountable with guilt. We don't convict juveniles and make them guilty. We adjudicate them, but they're incompetent due to their age. And we're going to hear about Colt Gray's incompetent issue because they have elected to prosecute him as an adult when very clearly he is not a physical adult, and arguably his brain is not that of an adult. How do we then make him accountable in a way that probably will lock him up for the rest of his life?
Yeah, and so much of that has yet to be seen. I mean, we're talking about day 3 of trial, multiple weeks. We're expecting for this to continue on. We are still have to hear from the defense. We still have to hear more testimony and more evidence come forward that had previously not been known to the public, let alone to these jurors, as they consider really all the facts of this trial. Looking at the past 2.5 days at this point, what are the strategies that you see playing out from both sides?
I believe the state wants to be and has maintained a very straightforward, honest prosecution. This has not been a gotcha or game playing. They want to keep this almost generic in we're the state doing our job. There was a person in the community that acted in such a reckless, unregulated, and illegal manner that they were warned many times not to allow their firearms, not to allow access to firearms for this young person that they're the dad of, they're the custodian of, they're in control of. That dad did allow the kid to have access, and the kid did these horrible things. Therefore, ladies and gentlemen, please convict dad. And here's the law under which I want you convict. That's the state's goal. Set out what happened in a clinical, not emotionless, but respectably emotional manner. It's gonna get more emotional. Even though many photographs and pieces of evidence are not going to be brought into the trial, certainly not displayed on camera, the jury will be shown photos that you can't unsee, and they will be traumatized. You cannot look at this evidence without it permanently affecting you. That is how strong and inflammatory and meaningful some of the physical evidence, I'm talking photographs, digital movies, things like that, you cannot predict how hard that stuff's going to land with jurors, because most jurors have never seen a dead child for all the right reasons. Confronting death like that is hard. The state's going to continue to do that in an eminently respectable, reasonable manner, and kind of throw that to the defense to disrupt a state that's quote unquote doing its job. And the defense will very carefully pick apart the arguments, not just relating to the facts, because there will be some factual disputes on when and where the messages were shared, how it landed with Colin Gray, whether these were serious, there's lots of stuff that they will do to refine on behalf of the defense, the actual interactions. But more, we're going to have to see some argument form through defense testimony that culpability should not lie with Colin Gray. And that can be lots of argument. Well, it wasn't just Colin. It was all these other people who missed the signs. Hey, it wasn't Colin Gray because it can't be a crime when someone else takes your gun and does bad things with it. There's the idea that Colin Gray and what's being testified to by the state is just a bad take, and it's being taken out of context, and it's a mountain out of a molehill. These weren't visits with law enforcement. This was a drop by where someone was like, "Hey, your kid's being a little bit wacky. Check into him." You know, there's lots of different pathways to minimize the impact of the state testimony, while also saying, please don't convict me. Because I don't think this is a case where Colin Gray can stand up and say, it wasn't me, I didn't do it. He was present. He was the custodial parent and very clearly made a situation where the firearms were able to be obtained by Colt Gray. We'll have to see how hard he fights back against that. So far, we've only got a one-sided presentation that they were just leaving these guns all over and buying ammo, and Colt Gray had basically could be armed in a matter of seconds.
Yeah, and we have to talk about what a massive deal this trial is and how consequential that it could be, not only for Colt Gray, who's still waiting for his day in court, but as you mentioned, the broader conversation around parental culpability, around gun rights, and what this could mean in terms of shaping state law and advocacy surrounding the issue of minors accessing firearms. And so I want to kind of focus in on outside of these two trials that we're going to be witnessing, that the nation is watching, is what we could see play out from an advocacy and lawmaking standpoint.
Well, very clearly, Second Amendment rights are a regular subject within our political discussion. Traditionally, progressives and the left have advocated for stronger regulation of firearms in the acquisition, background checks, in this case, storage, availability of arms, tracking arms. The left has traditionally supported more government action. Meanwhile, on the right, and especially at the more extreme parts of the spectrum, you see Second Amendment absolutists who believe that any infringement or regulation of firearms is per se wrong, unconstitutional, and they are fully set up and prepared to fight against any restriction on the ability for American citizens to own and possess and use firearms. It's a slippery slope, though, and it's a challenging argument. The right, especially here in Georgia, has acknowledged problems with firearms law and policy, deeply respecting the Second Amendment, so they go around to the other side when talking about guns. Hey, let's legislate the storage of guns. Let's legislate the availability of guns. And we've even seen as far as tax breaks for gun safes, because the GOP and the right here in Georgia and elsewhere understands the problem of overavailability of firearms, but is not going to impact a Second Amendment constitutional right when they have other available pathways to reduce firearms access. I expect some legislation in Georgia and elsewhere. That's going to be the kind of next discussion is, all right, gun owner, we let you buy whatever gun you want. How you handle it, how you carry it, how you keep it. We're now going to attach additional criminal and civil penalties because it's just wrong to allow something to fall into the hands of quote unquote bad people. I don't think anybody really understands how the loose guns issue exists. Buying a stolen gun is super easy. Why? Because criminals can't go buy a regular gun. So there's this whole marketplace of stolen firearms. The number of firearms stolen from cars in car break-ins is insane. Literally tens of thousands of firearms with no tracking, because it's illegal and we do not track firearms numbers. That's part of the meta argument about firearms policy in the United States. We can't track them. There's a massive population of stolen firearms out there, and those firearms are just as dangerous as any other one. So legislation, I believe, we'll also see exactly how inflamed the passions are based on both the state and defense arguments. The state wants to keep the Second Amendment passions non-existent, whereas the defense wants clearly to politicize this prosecution, threaten the Second Amendment rights of jurors, and force jurors to have a Second Amendment conversation in a jury room, not talking about this case, but the more existential, how does the Second Amendment work when you've got problems like this?
And we spoke yesterday in our day two analysis about the national precedent that this could set the outcome of a trial like this. And I want to kind of revisit that a little bit with you, because how central is the firearm? The fact that Colin Gray had gifted his son, Colt Gray, this firearm that was allegedly used in this mass shooting for Christmas the year prior. How central is it in Colin Gray's culpability? If, let's say, that the firearm had been stolen and it wasn't gifted, would we see Colin Gray on trial in this manner for these same charges?
Yeah, you're absolutely talking about the most central issue in the case. How did an incompetent child, because it doesn't matter what day of the week it is, he's a child. Children are incompetent. There are laws about providing firearms and who can own what and who. Doesn't mean that there aren't gifts of firearms every day in Georgia. I have gifted a firearm to a minor. It was 22. It's locked up in a gun safe. The ammo's locked up. I'm a really responsible firearms owner. Unfortunately, a lot of people aren't. And the state has aspirations about enforcing better gun policies with citizens at the exact same time as part of the state says, no, we do not regulate what people do with their firearms. That is a constitutional issue. There are people that very rightfully so advocate for the elimination of things like the National Firearms Act and the very limited laws that do regulate firearms here in Georgia and the rest of the United States. So exploring the relationship of how Colt Gray acquired the firearm, what the family relationship with that firearm was after the gifting through the shooting, jury's going to be really interested in that. Did dad say, here's your gun? When you're not shooting it, it stays in the safe that the kid doesn't have a combination to, and that seems super reasonable. As opposed to, hey, here's a gun. Yeah, I know, it just lays around your room and there's bullets everywhere and spare mags on your desk. It's just a gun. There are a lot of people who are pretty sloppy with their guns.
Context.
How do you criminalize that? How does that turn into a prosecution? What is the liability, not just criminal, which we're seeing now, but civilly? Because the gun universe is staring at this from all perspectives. This case could open the door to additional civil cases involving the responsibilities of firearms owners, even when their gun is used inappropriately or without their permission, such as, hey, I'm Josh. I'm going into a building, so I leave my firearm in my vehicle, but anybody could see that I left my firearm in the vehicle because I got out not wearing an empty holster, and then bad guy broke into my car, stole my gun, and did a bunch of bad things. Theoretically, I, as the firearm owner, could face allegations of negligence. Mr. Schiffer, you knew that guns get stolen from cars all the time, right? Yes. You'd been told and warned that this is a firearm, and you had to fill out a 1205 and do all this stuff in order to acquire it. And yeah, absolutely. And you just left it for anybody to grab. Do you think it's foreseeable that someone would steal a firearm? Well, yeah, there are thieves in the world, and firearms are good money. So it's totally foreseeable that your firearm could be stolen. And then crooks do bad things with guns, right? Well, yeah, crooks, I've been a criminal defense lawyer for 20-something years. Crooks use guns to harm people, rob people, threaten people. All right, so Mr. Schiffer, it was totally foreseeable that your care of your firearm resulted in it being stolen and then foreseeably used to rob and then shoot another person. Hey, let's watch it here. I put down my gun for 5 minutes. I shouldn't be exposed to civil or criminal law. That's the kind of calculus we're talking about. And it's not the easy facts that are worrisome. It's the extreme facts, it's the extraordinary facts, it's the rare facts where we find how the law actually works. When we see one prosecuting agency or law enforcement agency using a law aggressively, maliciously enforcing it, versus a community where that law is basically ignored. I'll tell you, firearms laws are ignored by law enforcement constantly. The number of I just had a little bit of weed with my firearm, well, that could be a federal case, could be a state case. It's a whole bunch of crimes. Cops regularly just get rid of the weed, don't deal with the gun, because it's a huge case that affects your firearm rights, and it's a giant fight, even though it's super duper illegal to smoke a joint and have a gun.
And this is what it would look like if Josh Schiffer was your criminal defense lawyer. I appreciate that play out of Josh and kind of painting the picture. When we're talking about the Colin Gray trial, and this is again day 3, we are expecting up to 3 weeks possibly of this trial to continue. So we have a lot of conversation, a lot still to see, a lot of evidence still to be presented. But it seems to be ramping up quite rapidly as we get more and more into this. So for the jury, each day that they're coming in with the previous day fresh on their mind and kind of looking to get their individual questions answered that will lead them in deliberations, I guess, what's their mindset right now? Where are they at?
So they are very aware of the length, scope, and prominence of this case. There's no way they can ignore it. This is a jury picked from a different county and then brought back to Barrow County for the actual trial. That's to make sure that the jury pool was less impacted by the press coverage. So this jury is actually from Hall County, but they absolutely know the size and scope and importance of this case, and that's going to impact how.
I do believe we just lost criminal defense attorney Josh Schiffer here joining us with analysis. We are expecting trial to resume here in 5 minutes at 12:45. We'll take you back into court as we continue to bring you gavel-to-gavel coverage of Colin Gray's trial here on ANF Plus. You can watch us on Roku, Apple TV, Fire TV, YouTube Live, and of course download the Atlanta News First app. Any major developments in this trial, we will send a push notification directly to your phone so you don't miss a thing. In the meantime, I'm going to bring you back inside of the courtroom. Right now, we just have a slate up, a seal for you. But as soon as court resumes, again, that expected time is 12:45. You will see the judge, you will see the attorneys, and you will see, of course, Mr. Colin Gray in the room. We will continue to bring you coverage. Our live analysis happens every day at noon. Make sure to tune in as we bring criminal defense attorney Josh Schiffer back on with us, breaking down day by day, moment by moment, what you're seeing unfold in court. Stick with us. We'll be right back.